A very warm afternoon to all of you. I welcome you all to the third seminar of the year 2022. Today's topic is right to private defense on person and property. So, without taking much of your time, may I invite on stage Sri Sankarsan Mishra sir, the chairman seminar committee, to come up onto the dais, please. Thank you, sir. Now, may I request Shri Ashok Joshi, sir, the speaker of the day, to grace the dais, please. Thank you. Thank you, sir. Now, may I request the Secretary District Bar Association, Sri Harihara Pradhan, sir, to come up onto the dais, please. May I now request the chairman seminar committee to preside over the meeting. Thank you so much.
Good afternoon to all. My esteemed colleagues, today we are going to start our third seminar. We are fortunate enough that in this seminar we are having a very learned advocate, senior advocate, Shri Ashok Joshi, to be our speaker in this occasion. But it is really disheartening seeing the poor presence, poor attendance. So I'd like to request my all junior and senior friends at least to participate in all seminars to enable themselves and also enable the committee and the speaker. Today's topic is, as it is earlier declared, right of private defense on property and person and property. I would like to request Shri Ashok Joshi, Advocate Bargarh, to speak on this topic. Shri Joshi.
Respected Chairman Seminar Committee, respected Secretary, District Bargarh Bar Association, senior members and junior friends. The subject which was given to me is about right of private defense to person and right of private defense to property. Earlier, Mr. Sahu has given a talk on about the general explanation which we find in the IPC regarding right to private defense and other exceptions. And on that day, I have also heard the deliberations of Mr. Sahu. And there a thought come to my mind that whether right of private defense and right of property, defense of property, is necessary nowadays or not. Because those who are in the criminal side, those who are practicing in the criminal side, they know that simply the defense denies the allegations and it is the duty of the prosecution to prove the prosecution case beyond reasonable doubt. So generally, whenever a criminal case we conduct, there we take the plea of denial. But I would like to apprise you that earlier, when our seniors in the bygone days, they were taking the plea of right of private defense to person and right of private defense to property, and at that time they were not denying the case of prosecution as false. They were admitting that yes, there was an occurrence, and in that occurrence these things has happened, but while exercising my right of private defense to my person or to my property, this has happened, so I should be excused or I should be acquitted from the charges. This was the day in the earlier in the 40s and 50s. Till 60s also, such pleas were taken by the criminal lawyers, and at that time, the honorable judges, they were appreciating such pleas of the accused person or of the defense, and they were also acquitting the guilty persons. Now, the criminal law is a flowing thing, flowing water. We cannot say that this was the decision in the year 1950 by the Supreme Court or by the Privy Council or by any High Court, and this should be always be correct, because the law changes according to the circumstances, according to the society, according to the time, according to the requirement. Therefore, after 1990s, decisions were coming where they were accepting the version of the prosecution rather the denial plea of the accused persons. And to such an extent, now the court are telling that simply saying that it should be beyond reasonable doubt is not enough. The doubt shall be according beyond the logic. If the doubt is not logical, then you can convict the person. This is now this trend is going on. That is why the right of private defense of person and property is nowadays necessary for us. And you might have come across decisions where you have seen that why the prosecution or why the victim or why the informant will tell lies against the accused person. That is not the lookout of the defense till now. But nowadays, you have to go and show or give an explanation that these are the reasons for which I have been wrongly prosecuted. So such situations are changing. These circumstances are changing in the criminal law, appreciation of criminal evidence. That is why right of private defense of person and right of private defense to property is nowadays necessary for youngsters who will be practicing in criminal side. Now, the most important thing in the right of private defense to person and right of private defense to property is proportion. What I find that if it is disproportionate to the case, then that defense will not be allowed. It should be proportionate to the attack or to the allegation And if you can show that no, my defense is proportionate or less than the attack made on me or attack on my property. So that is why if you will threadbarely examine the right of private defense and right of property, we find various examples. Supposing regarding weapon of offense, regarding manner of assault, regarding number of persons, regarding time. So the most, when I am telling about you the time, the most important thing is whether the person who is exercising his right of private defense to person or property has sufficient time to take recourse of law. If a person has time to run to the police station to get the assistance of other persons, then he cannot exercise his right of private defense. Why you attacked, why you did not complain to the police, or why you took this such step without informing the village gentries. So such things are there. Now, supposing a person is coming to attack me with a lathi and I have a pistol, what will happen? If I will fire the pistol, I will exceed my right because it will be disproportionate to the weapon of offense, disproportionate to the assault. So I cannot fire. Then what should be my right of private defense? I can protect my person and I should find out another lathi or another piece of stone or something so that I can show that no, I was within my right of private defense, and when I found the person attacking me with a lathi, I used this lathi or I used this stone. So such thing should always be run in our mind. So also, as regards the right of private defense to property, what happens? Supposing somebody is cutting away my crop from my land, and I am unable to protect my property. In that event, if I will attack, then there is some right of private defense to my property. But supposing after cutting the crop, the person is running away with the crop, and I will chase him and kill him, or I will assault him, I will not get the benefit of right of private defense. So such minor things should be kept in our mind. A thief, you found a thief inside your house, you caught hold of him, you thrashed him, you assaulted him, so long as he is inside your house, it is all right. Supposing somehow he escaped from your clutches, runs away from your house, you chase him and give him a lathi blow, you lose your right of private defense there. So such technicalities are always to be kept in mind. Once he crosses the threshold of your house and tries to escape, then you lose your right of private defense to your person or to your property. So it is a very wide subject, and there are many more examples to be seen. Where, supposing in another example I will give, that a group of persons with lathis, they are attacking the police personnel, and the police personnel in exercise of his right of private defense, fires. He fires a rifle. Then in that event, he will be within the, he will come or he will get the benefit of right of private defense to each person, because number of persons with lathis or with weapons are more violent or more volatile than the single rifle. So in that event, the police can take the plea of right of private defense. So as regards property also, the same principles apply, whether you are within your limit or not, or whether you are crossing the limit, or your act is disproportionate to the act from the other side. So in sum total, this is the sum and substance of right of private defense, and it is very much necessary nowadays because the criminal law is changing. We cannot say that beyond reasonable doubt, or we cannot always take the plea of denial. And I think for today, I will stop my deliberations here, because there are many situations. If any of you have any question regarding any situations, whether right of private defense accrues to you or not, or right of private defense to your person or property accrues or not, if you will question me by citing some example, I can try to answer.